Assalamualaikum warahmatullahi wabarakatuh. My name is Shazril Khairy bin Mustafa, First Counsel. The First Counsel representing on behalf of the appellant. Together with me is Bidayatun, Second Counsel. Ya Ma'arif, Ya Arif, Ya Arif. Today has been fixed as the date of hearing for this matter. If it pleases the court, I would like to enlighten this honorable court with the material fact on behalf of the appellant. So the appellant was charged under section 302 of the Penal Code for the murder of the deceased, one Gonding bin Masirin. We would like to bring the attention, Ya Arif, on the relationship between the appellant and deceased. The appellant is the son-in-law of the deceased. At all the material time, the appellant is having a dispute with marriage with the deceased daughter, which still taking place at the Sharia court. On 6 March 2013, the appellant went to his friend house meeting at the Esplicin, which is nearby from the deceased house, the place of the incident, to peel mango with his friend. On his way back from his friend's house at 1:30 p.m., he passed by the place of the incident and saw his daughter. The appellant asked her daughter in deceased's house to come back with him, but she refused. The deceased said to the appellant for the forcing her. Upon hearing the deceased word uttered, the appellant felt provoked and he lost his self-control. At the same time, the wife to the deceased, PW10, has bring to the daughter inside the house. The appellant felt upset and tried to get his daughter back, but the deceased later hit him from the back. The act of PW10 apparently had caused the appellant to feel his right to deprive, and at the same time he was also attacked the deceased. Since there is quarrel between the appellant and deceased, the appellant was reluctant to use the knife, and his wish was used to peel the mango and cause injury to the deceased. The deceased had died to the injury caused by the appellant. Ya Arif, the learned High Court, the judge has convicted the accused for the sentence of the murder under section 302 of the Penal Code. The hearing today has been fixed for the appeal, where the ground of our appeal are based on three issues. First issue, whether there is a prima facie case. Second, whether the court may conclude there is a prima facie solely on the statement from PW3, PW5 and PW10. As an alternative, in any situation, the Honorable Court decide that prima facie case has been established. We humbly submit the third issue is whether there is no grave and sudden provocation. I'm Shazril. I will deal the first and second issue, and my fellow counsel Bidayatun will deal with the third issue. Ya Ma'arif, Ya Arif, may it please the court. Now I am beginning submission for the appeal. The first issue is the issue law whether there is a prima facie case has been established by the court. We submit that the main issue is to determine the conviction of the appellant is whether the prima facie case has been established by the prosecution. Prima facie is well-established law that was accumulated from number of cases by the number of judges that took decades until this principle has been laid down in section 173 and 180 of the criminal procedure for both subordinate court and high court respectively as guideline in criminal trial. Since this case was heard before the high court criminal court, the have obligation to the follow to the rule laid under section 180 subsection 1 and subsection 2 of the criminal procedure code. I would like to refer to this case to tab 1 of the appellant bundle authorities. Yarif, this provision is clear and straightforward provision which has not been contested for years until today. We also like to refer the Honorable Court to the case of Muhammad Imran Ramli and Anna against PP. May it refer Honorable to the tab 2 of the appellant bundle of authority in page 4 in paragraph 16 and 17. In this Muhammad Ramli and Anna against PP case, the Court of the Appeal has took a strict approach by requiring all the elements of the offence to be established first. This include first an intention to inflict that particular bodily injuries, and secondly the injuries sufficient to cause death in ordinary course of nature. We also raise this first issue to Honorable Court in respects of the section 180 submission 4 of Criminal Procedure Code Act 593. May it refer to the tab of 3 of the appellant bundles of authority, which the 180 submission 4 clause 4 of the CPC state as follows. For the purpose of this section, a prima facie case can be made out against the accused where the prosecution has adduced credible evidence proving each ingredient of the offence, which if unrebutted or unexplained would warrant a conviction. Referring to the above provision, we would like to emphasize that the court may only decide that there is a prima facie case when the prosecution has adduced credible evidence, which we would like to explain further in second issue. So in second issue, we refer about the second issue whether the court may conclude there is prima facie solely on the statement from PW3, PW5 and PW10. This issue also at the same time will determine whether there is a prima facie or not. This issue was raised not simply because PW3, PW5 and PW10 are the relative of deceased, but because all these witnesses have shown some discrepancies and inconsistencies in their statement during the cross-examination in the trial of the High Court. Ya Arif, Ya Arif, it is not a secret anymore that PW3, PW5 and PW10, the witnesses will give the statement that lead to the prosecution case relative to the deceased and each another. These facts of their connection, however, is not something ordinary anymore, and His Honorable Court need to ponder upon, since we humbly submit to the court that there are the distinction of the facts that was brought by the prosecution that may raise a doubt. We refer the Honorable Court to the record of appeal notes of evidence during the trial as follows. If Yang Arif, I would like to speak in Malay. Question 306, kamu tidak bercakap benar sebab isteri kamu sendiri cakap semasa kamu beri keterangan ke rumah abang kamu dan kamu hanya sampai di tempat kejadian, bapa mertua kamu sudah terbaring. Setuju? That's the answer is setuju. On the next question, the question 307, artinya kamu setuju bila kamu katakan kamu tidak bercakap benar. That answer is benar. And the sixth, this one of the cross-examination to the PW that was done under section 180 submission 1 and bracket 1 and bracket 2 of the CPC is under the provision where the judge must apply the maximum standard of proving beyond reasonable doubt, we have submit in our first issue. We humbly submit that the has failed to identify that actually there is a doubt from the discrepancies and inconsistency of statement raised by PW5. We humbly submit to the court this is a discrepancies and inconsistencies is a crucial which the High Court judge had failed to consider upon from simply error and decide that there is prima facie at the end of prosecution case. This concern has been raised by Raja Azransha in the case of the Leong Siong Long against PP. May I refer the court the tab 4 of the appellant bundle of the authority at page 577 and 578 on the highlighted paragraph, which state as follows. Testimony of an close relationship is not tainted if otherwise reliable in since that witnesses are competent witnesses who were the scenes of occurrence and could have seen what happened. But it is proof that there are entire disinterested witnesses. Example, they are either partisans of the complainants or are in any inimical to the accused. Then their testimony is tainted and requires corroboration if to be acted upon. In our submission on the first and second issues, we further conclude to the court that first, the prosecution has solely relied on the statement PW3, PW5 and PW10 to establish prosecution case. PW3, PW5 and PW10 are close relative to the deceased and or partisans of the complainant. There is slightly discrepancy from the evidence adduced by the prosecution through the PW5 and is not corroborating to the other evidence. And last, therefore, they shall to be prima facie at the end the prosecution case.
I'm Arif. I'm Bidayatun Solehah binti Abdullah, second counsel for the appellants. I will deal with the third issue, which is whether there is no grave and sudden provocation as an alternative in any situation that this honourable court decided that prima facie case has been established. We humbly submit this third issue proposing that there is a grave and sudden provocation. We acknowledge that grave and sudden provocation does not simply apply in any ordinary events. This is as stated in the case of Cik Omar Muhammad Ahir versus Public Prosecutor. May I refer the court to tab 5 of the appellant's bundle of authority, page 290, paragraph 17, which state as follows. Thus, in order to successfully set up provocation as a defense for the reduction of the offence of murder to one of culpable homicide not amounting to murder, it is not enough to show that the accused was provoked into losing his self-control. It must be shown that the provocation was grave and sudden and must have, by its gravity and suddenness, caused a reasonable man to lose his self-control and induce him to do the acts which caused the death of the deceased. In determining that question, the court may also consider, along with other factors, the nature of the retaliation by the accused, having regard to the nature of the provocation. By not disputing the law and referring to the same standards of application, we submit that LHCJ has erred in determining the facts and the acts of the deceased as not grave and sudden provocation. We submit that the court must understand the nature of the provocation not merely by looking at a single sentence of the words uttered by the deceased alone, but the court must understand the nature of retaliation by the accused, having regard to the nature of the provocation, as in the above case. Looking at the fact of the case, we submit that the appellant was being provoked not by a single sentence of the deceased, but by a series of acts that ended in the last sentence that seems nice, that not provocation at all. We would like to refer the court to the fact that at all material times, we appellant is having a dispute with the marriage with her wife, which is the deceased daughters, which still taking place at the Sharia family court. This dispute is a serious matter which may affect the condition of the appellants. Therefore, even a single word may be considered as grave and sudden provocation by looking at the whole circumstances. This principle is well established principle that was laid down in the case of Matsawi bin Bahudin versus Public Prosecutor, tab 6 of the appellant's bundle of authorities, page 10 at the highlighted paragraph, which state that the condition that the provocation could be cumulative. The judgment states as follows. If On the other hand, the case is one in which the view might fairly be taken. A. That a reasonable person, in consequence of the provocation received, might be so rendered subject to fashion or loss of control as to be led to use his violence with fatal result. And B. That the accused was in fact acting under the stress of such provocation, then it is for the jury to determine whether, on its view of the facts, manslaughter or murder is the appropriate verdict. Yang Amat Arif, Yang Arif, in the case of Maksawi bin Bahudin, the judge has accepted the ground of sudden, grave and provocation that has substituted from the conviction of murder to a conviction of culpable homicide, not amounting to murder. Yang Amat Arif, Yang Arif, we humbly submit that there is a grave and sudden provocation from the series of conflict raised by the deceased before this accident that led to this tragic accident. We submit that this ground explain how could the appellants who is in this case is a reasonable person as a father to a daughter could do such thing to his own relatives. We humbly pray that the appellants appeal to be allowed. We are obligated.
If it pleases your Lordship, my name is Ranusha Thanabalasingam and I represent the respondent together with my learned co-counsel Mr. Murali Raj. My Lord, the respondents submit that the three grounds of appeal put forward by the appellant are devoid of any merits. My Lord, on the first ground of appeal, the respondent submits that the learned trial judge had not misdirected himself and did not err in law when he decided that there is a prima facie case brought by the prosecution for the charge under Section 302 of the Penal Code. My Lord, I will address your Lordship on this ground of appeal. On the second ground of appeal, the respondent submits that the learned trial judge has not erred in law in deciding that there is no discrepancy in the statement of the witnesses to form the case for prosecution. My Lord, I will be addressing your Lordship on this ground of appeal. For the third and final ground of appeal, the respondent humbly submits that there is no appealable error warranting this appeal and that the learned High Court judge had correctly applied the principle and applicable law when he decided that there is no element of self-defense or grave and sudden provocation in this case. My learned co-counsel Mr. Murali Raj will address your Lordship on this ground of appeal. With your Lordship's permission, the respondent proposes 7 minutes of our time for the first and second ground of appeal, and for the third ground of appeal, the respondent proposes to allocate 7 minutes of our time. If your Lordship has no preliminary questions, I shall proceed with my first submission. My Lord, for the first issue of whether there is a prima facie case based on the facts, it is uncontested that there was indeed a quarrel between the appellant and the deceased. The deceased suffered physical harm, sustained injuries, and the deceased died due to those injuries. My Lord, with your permission, I would like to refer to the case of Muhammad Imran Muhammad Ramli and another against public prosecutor which took place in the year of 2020, which can be found at tab 2 page 4 of the appellant's bundle of authorities, in which the 4 principles laid down were established. Namely, the 4 principles were: bodily injuries are to be present, the nature of the injury should be proven, an intention to inflict that particular bodily injury should be present, and the injury should be sufficient to cause death. The appellants had raised the issue of whether there was credible evidence to prove a prima facie case in accordance with Section 180 subsection 4 of the Penal Code. It is to be duly noted that indeed there was credible evidence adduced. All 4 principles were established. Principles 1 and 2 without doubt was established. As for principles 3 and 4, beyond reasonable doubt, it should be noted that the accused indeed had the intention of inflicting those bodily injuries, as he had a knife with him. My Lord, no common man with the intention of wanting the return of his wife would appear with a knife in his hand. Also, the post-mortem report revealed that the cause of death of deceased was due to 6 stab wounds. Anyone who had no intention of causing bodily injuries would not have stabbed someone 6 times continuously. This, my Lord, also proves the 4th principle that the injuries were sufficient to cause death. Therefore, All four principles were proven, thus proving that a prima facie case was proven. Lordship's permission, I shall now proceed to my second submission. My Lords, for the second issue of whether the court may conclude that there is a prima facie case solely on the statement of the witnesses, who are the relatives of the deceased, the respondents submit that the relationship between the deceased and the witnesses is irrelevant. With your permission, my Lord, I would like to refer to the case of Liao Xiao Long against public prosecutor, which took place in the year of 1969. In this case, it was held that the evidence of close partners and relations is not defiled because it is otherwise credible in the statement that the witnesses are capable witnesses at the scene of the incident and should have seen what had occurred. Therefore, it is determined that the witnesses did in no way give their testimonies only to be in favor of the deceased, but rather because they were the only ones who saw the unfortunate incident and testified accordingly. Hence, we the respondents humbly submit that the learned judge did not err in law and dismiss the appellant's appeal. Unless I can be of further assistance to your Lordship, that concludes my submission.
May it please your Lordship, as it been indicated by my learned friend Miss Ranusha, and my name is Murali Raj, and I appear for the respondent on the third and final grounds of appeal. My Lord, my learned co-counsel has already submitted to your Lordship the first and second grounds of appeal. I shall now proceed to discuss the final grounds of appeal, that there is no error in law when there is no elements of self-defense or grave and sudden provocation in this case. If your Lordship has no preliminary question, I shall proceed to my submission. My Lord, for the third issue of whether there is a grave or sudden provocation, it is to be duly noted that, based on the facts, that the deceased only told the accused not to force the daughter, and that these words were common in nature. Also, the accused the accused mother-in-law did not push the daughter of the accused into the room. She merely brought her into her house in the most common way possible, with the intention of not wanting a child to witness her parents in an argument. So basically, the grandmother wants to avoid the daughter to see all this argument the parents are going through. Okay, the accused's sense of provocation, unjust feeling, and lack of self-control clearly demonstrate that the accused is a bad-tempered individually. My learned opponent has quoted the case of Che Omar Ahir versus PP to highlighted the provocation was grave and sudden, and must have, by its gravity and suddenness, cause a reasonable man to lose his self-control and induce him to do the act which caused the death of a deceased. It should be noted that the argument which took place were such simple arguments which in no way should cause such an outrage of anger to any common man. Besides, the appellant also referred to the case of Mat Sawi bin Bahudain versus PP, specifically referred to the issue of provocation could not be cumulative. They had brought up the issue that the accused was still having dispute with his wife, which was still taking place at the Sharia family court, which could be a reason he was upset or angry. My lord, it should be noted that the accused disputes with his wife in no way alter his condition. It is not a valid grounds to prove that this series of events prove that the provocation was cumulative. Also, there was no medical expert who could support the accused said condition. For the reason we have given, the respondent prays that this appeal be dismissed. Unless I can be of any further assistance to your lordship. That concludes my submission. Much obliged, my lord.